Good evening. We'd like to welcome you to our fifth installment of our 6-Point Wealth educational series, designed to empower you with the knowledge you need for sound financial planning. In our previous sessions, we've covered Estate Planning 101, the role of an executor, death and taxes, and estate expenses. If you missed any of these sessions or would like to view them again, we have them posted to our YouTube channel. After this webinar, we will be emailing you a recording of this session as well as the previous webinars. Today, ClearEstate, our estate planning partner, will shine a spotlight on advanced estate planning. From ClearEstate, we have with us again Ellie Muir, Team Lead of Partner Relations. She oversees the teams of account managers that we work with as a first line of contact at ClearEstate. We're taking a similar approach to last time where we've pre-recorded the presentation. Throughout the presentation, though, we do ask you to send your questions through the question feature in the bottom right-hand corner of your screen. Today's webinar is going to be led by Melinda Oliver, former estate planner at ClearEstate, who's now an external advisor. She has extensive knowledge and experience in estate planning with a legal background and over 10 years of experience as a tax and estate planning practitioner. We believe having a comprehensive estate plan is one of the most valuable gifts you can give your loved ones after you're gone. Thoughtful planning not only ensures that your wishes will be honored, but it will also result in significant time and financial savings and greatly reduce the stress on your loved ones when the time does come. Today's webinar is going to equip you with the knowledge to make informed decisions that safeguard your estate and ensure your loved ones are set up for success when the time does come. Today, we're going to cover probate planning, protecting against marital breakdown and creditors, living trusts and testamentary trusts, business interests, complex family dynamics, and beneficiaries with disabilities. As a reminder, this session is being recorded for our YouTube channel. I'll now hand the floor over to Melinda.
Thanks, Mike. I'll get it started here. Welcome, everyone. Just a reminder that if you want to put in a question, we will have plenty of time to get to your questions at the end. And if you type a question into the question box, it will only be visible to me, John, and Mike, and not to the other participants in the webinar this evening. And with that, I will start the file.
Hi, everyone. Thank you for taking the time today to come hear us as we move into advanced estate planning. By way of introduction, my name is Melinda, and I am an estate planner here at ClearEstate. I have about 15 years of estate planning experience with a tax background as well. So we're talking about transferring wealth from one generation to the next, whether during your lifetime or on your death, and we're bringing that experience to you today in this presentation. So increased complexity in both family dynamics and assets frequently results in increased complexity in your estate plan. But you might be able to plan for this complexity in advance. We're going to go through some of the strategies today that may be available to you in that advanced planning. Advanced planning is important because it can prevent unintended consequences in your estate. Some of those unintended consequences might be increased taxes, but it also might be family disharmony. And we want to try and promote as much family harmony as we can. So quickly, our agenda is we're going to go through probate, the probate process. What is it? Is it required? Do we need to plan around it? Does that make sense? And then we're going to go into some of those strategies that are either during your lifetime or on your passing. And different considerations you might have in deciding whether you want to engage in some advanced planning at this time. So what is ClearEstate? ClearEstate is a one-stop shop for estate planning and settlement. We use a platform that we've developed in-house to make the process more efficient for your loved ones. As you probably know, estate planning is really a gift for the next generation or for the persons who are coming after you. We want to make it as easy for them as possible. So it's advanced work now for easier living later. We provide families with support during the process, either in planning or in settlement. So it's very much customized to their particular situation. And we want to empower you to help your loved one's estate being settled. But if it's your own estate, we want to empower you with the right strategies, the right discipline to make sure everything is done in advance. And again, we're preventing those unintended consequences. So today, what will you learn? In addition to what is probate, which is often misunderstood, we're also going to learn about the benefits of certain advanced estate planning strategies. We're going to learn about the considerations for such strategies. When are they useful? When are they not useful? Because just because they're great strategies doesn't mean they're for everyone. And how you can take that next step to get help with your estate planning. So what is probate? At its simplest terms, probate is the judicial process whereby a will, or if there isn't one, there's already rules set out in called the intestate rules, and the estate's representative's authority is legal verified. So basically, it's taking all the information about the deceased, their will if they have one, their beneficiaries, sending it into court and having a judge review and certify that this is the appropriate person to act. These are the assets of the estate, and this is how they're going to be distributed. Probate is not actually a straight legal requirement. It's more of an institutional requirement. It's when third parties require proof of the estate representative's authority, because those parties, and they're typically, land titles or financial institutions, don't want to be held liable for accepting direction from the wrong party or transferring assets to the wrong person. And that liability could be on those third parties, the financial institutions and land titles, but it can also be on the personal representative if it turns out they were not the right person to act, or if they were acting inappropriately. So again, it's that extra level of certification so that all these other parties can take comfort that they took the right steps to respect your wishes, or if you didn't do a will, what the law says needs to happen. So what is probate in terms of the process? It is a long process. Typically, it's at a minimum several weeks, depending on the jurisdiction, but often it's more than months, and occasionally it can take more than a year. And there's fees associated with it. Ontario, of course, has the highest probate fees in Canada, and it's called the estate administration tax. And it's roughly 1.5% of the value of the estate. There's, up to 50,000, it's a little bit lower. But those are the highest fees in Canada. So often we do have clients who are engaging in probate planning in Ontario. BC is the next highest at about 1.4%. So any of you in BC, you're still in these, and some of these strategies could be useful for avoiding probate. But in terms of not just the cost, because it can take so long, you're saving time. If you can get assets out of probate and it's appropriate for you and your wishes, and also privacy, because once a document goes into court, it can become public record, and people can run searches for a fee and obtain a copy of the probate package, which would include your will. It includes beneficiary information. So sometimes for privacy reasons, people like to plan around probate. So 3 main reasons for our potential probate planning strategies: the time it takes to get probate, the potential cost that can be associated with probate and is paid by the estate, and privacy. So our first strategy in advanced estate planning does get you out of probate because it's inter vivos giving. And any of you who are familiar with Latin would know that inter vivos means between the living. And it is exactly as it sounds. It's giving gifts while you're alive. Now, this can be a great tool. In Canada, we don't have a gift tax, so there's no unintended tax consequences unless there is an inherent gain in the asset. So you want to really talk with your advisor about whether it's appropriate or feasible to give during your lifetime if it's assets that have increased in value, which might be a family cottage, or it could be an investment account. There could be unintended tax consequences there, but if you're just giving a cash gift, there's no consequences. The other thing you want to be leery of in inter vivos giving is making sure that you have enough for your own needs for your lifetime. Of course, a gift once given can't be demanded back. And so we want to make sure as part of our advanced planning that you have enough for you if you do want to engage in inter vivos giving. The second strategy we'll go into is joint tenancy, which is a way of owning property with another person. In this particular one, you each have effectively 100% interest in the property. It has a right of survivorship. So when one of you passes, the other one automatically has a full interest in the property and becomes the sole owner. The other form of owning property with another person is called tenants in common, and that's where you have a defined interest. So it's important to check the ownership, particularly around real estate, to determine which type of ownership you do have with that other person. If it's joint tenancy, you can probably get out of probate because of that right of survivorship. But if it's tenants in common, you each have a defined share, and your share will form part of your estate and have to go through probate. We say typically, it doesn't form part of your estate until the last of you to die because of that right of survivorship. However, you do need to be careful if you're adding someone as part of your, not end of life planning, but nearer the end as a probate tool. because there might be those unintended consequences when you transfer part of your asset to someone else. So if you add someone onto a bank account, even if it's just to pay bills or an investment account, you could be deemed to have disposed of part of that asset and capital gains tax could be payable. There's also a presumption of resulting trust from the Pecor case. So adding, a child onto an investment account, there is a presumption that that's not a gift to the child, that it's meant to be for the estate, and that could bring the asset back into probate. So it's important that you're getting appropriate advice from your advisors, but this strategy is available and it's very useful, particularly between spouses and when you're initially starting out. Another name for joint tenancy is joint with a right of survivorship. So again, it's just not to be confused with tenants in common, where you each have a defined share and is likely what you would use for owning assets with business partners or potentially persons outside of your family. But joint tenants is often how assets are owned between spouses with that right of survivorship. The third strategy is very, very common, and that's beneficiary designations. Many assets, such as registered accounts like RRSPs or TFSAs, you're allowed to name a beneficiary. Life insurance would be another option for an asset where you can name a beneficiary, and the asset will flow directly to that beneficiary without having to go through probate. So it's a way to remove some assets. What to consider with these ones, though, is if it is a taxable event, so an RRSP, for example, or a RIF is an income inclusion when you pass, who is liable for that tax? The default position is that the beneficiary named will get the full amount and the estate is responsible for the tax, but that doesn't always accomplish your gifts or your wishes for your estate. And an example of that might be if you have a home worth $1 million and an RRSP worth $1 million, and you think it's easy peasy, I've got two kids, one will get the home, one will get the RRSP. But that might not be that they're each getting equal amounts, because the child who's named on the RRSP will get the full amount of the RRSP. The child getting the home might have to sell the house to pay the taxes on the estate and will therefore get a significant lower amount. So it's important to plan around your beneficiary designations. Simply making them might not be sufficient. You want to think about who bears the tax burden and is there sufficient liquidity there for it. But at its easiest and simplest thing, beneficiary designations stay out of probate and they can go directly to the named beneficiary. A fourth strategy that we see, especially in those high probate fee jurisdictions like Ontario and BC, is the strategy of multiple wills. One is around probate planning, because not all assets need to go through probate. As I'd mentioned before, it's more of an institutional requirement. So certain assets such as private company shares, certain personal assets may not need to go through probate, and you can have a secondary will to cover those assets and keep those values out of probate and out of that long length of time that it could take to deal with them, which can be especially important in private companies that might be operating companies. However, there's wording that needs to exist in both wills: the primary will covering the assets that must go through probate and the secondary will covering the assets that don't, so that they can exist together, because typically when you do a new will, it revokes the previous will. So we need to work very carefully and make sure the correct wording is in each will so that it's clearly defined which assets are covered under each will and that they can exist at the same time. Another case where a multiple will could be useful is if you have assets in different jurisdictions. All across North America, the formal requirements are pretty much the same, province by province, state by state. So you can use, for example, an Ontario will in Florida. However, it has to go through the probate process in Ontario first, and then it can be resealed in Florida. So it's adding extra time onto your estate. As such, many people will prefer to do a will in the jurisdiction where that asset is held. So in this example, in Florida, so that they can go through probate at the same time and save time for your beneficiaries. Again, in that instance, even though we're not doing probate planning, you need to have certain wording inside the wills so that they exist at the same time and one hasn't revoked the other. So it's a wording issue and making sure that they're able to exist concurrently. And I'll leave this slide for a little bit so you can see what type of shares or what type of assets could be used in a multiple will situation. And it's typically assets in another jurisdiction or assets that don't have to go through probate. Another strategy is not really a probate planning strategy, which has been the focus so far, but it's more of a family strategy, and that's testamentary trusts. And these are trusts that are set up by a testamentary document. So you can determine all of the terms and how they operate during your lifetime and during your planning process, but they won't take effect until you pass away. And so in these testamentary trusts, you would name the trustee, and it could be your executor, but you can always name someone else if that's a more appropriate choice, that will then hold the asset on behalf of the beneficiaries. A trust, in its nutshell, is the severing of ownership into legal title and beneficial title. So your trustee holds the assets, manages the assets, and is responsible for them, but everything is for the benefit of the beneficiaries. You can choose in those terms how the income is distributed, at what point or upon which events income is distributed to them, and also capital. So typically we see there's a power of encroachment of capital. So the assets are there and they're available for the beneficiaries of the trust for the duration of it, but it's the trustee who decides whether some of that capital is distributed early or whether it's preserved inside of the trust. And you would set those out in advance in the trust terms. There's a few different types of testamentary trusts. One of the most common one would be trusts for minors. As you're probably familiar, most persons, actually all persons under the age of majority, and the age of majority does vary province by province, so you'd want to confirm that. In Ontario, for example, it is age 18, but most or all beneficiaries under age 18 can't receive large inheritances. It does need to be held in trust. In the absence of setting up a proper testamentary trust in your will, it could be the public trustee that would hold those funds until your minor beneficiary becomes the age of majority. And so if you're putting it in your will, you can prevent that need for the public trustee to be involved. And you can also set out specific terms to dictate how the trustees to release the funds, give them that discretion on power of encroachment if it's appropriate, and dealing with how income and capital is to be distributed, whether it's meant for tax efficient purposes or other purposes such as education or travel or the purchase of a home, depending on how long you want to keep these trusts going. And you can name the age, because for many people, 18 might be a little bit young, depending on the value of the assets going into the testamentary trust. Often people will choose a slightly higher age, like 21 or 25 or 30, where they think the financial literacy of the beneficiary might be a little bit stronger. You also have the option, if you're setting it up in your testamentary documents, to do staggered payments. So you could say a certain percentage at 21 and the balance at 25. It's really, there's a lot of flexibility in how you could set up these testamentary documents, but the advantage of setting them up is you do get to choose what those terms are. In the absence of anything, it is the age of majority and likely the public trustee who will be making those decisions. Spousal trusts is another option that is often set up through testamentary documents. You can set them up on an inter vivos basis, but typically we see them as testamentary trusts, and they're often used in blended families, because the advantage of a spousal trust is any assets going into the spousal trust can take advantage of the spousal rollover. So there's a deferral of tax of assets going to the spouse, and the spouse has the use of all the assets for their lifetime. But when the spouse passes, it doesn't go into their estate. It goes back to your estate. So it can be distributed to your named beneficiaries. And that's why in blended families, it's often used so that it comes back to your estate and could go to your children, as opposed to potentially a second spouse of your spouse or their family members, which might not be what you had intended when you first started to build your wealth. As I mentioned before, there's a tax deferred basis because it is for the spouse and only for the benefit of the spouse. So there could be some tax savings there, or at least deferred, maybe not savings, but definitely deferral. But a restriction is that it is only for the spouse for their lifetime. So if, for example, you wanted to have some flexibility for gifting to other family members or to charities, it may not be the best option for you. Okay. Another testamentary trust that we see fairly frequently is protective trust, which is a rather broad umbrella term, but it really just means if you have specific beneficiaries that might be a little bit vulnerable, you can set up these protective trusts to not just dictate how and when the trustee will release funds to those beneficiaries, but also to provide a certain degree of asset protection, whether it's from a future relationship of the beneficiary, whether it's from the beneficiary themselves, if maybe they're not that strong with money and they don't, there's no expectation that they will become better with money. So, or, even creditor protection. So there's this degree of asset protection in all of the trusts, but in protective trusts, it's the primary concern. And so there's often additional language in there to beef it up. And you want to make sure there's maybe an independent trustee there as well to add that extra level of protection for those beneficiaries who may need it. And just to kind of summarize, persons who may be good candidates for a protective trust would be beneficiaries who are not great with money. If there's concerns about relationship and you want to preserve your family legacy for your family, or if potentially there's just some vulnerabilities there that we want to make sure the trust is kept intact for a long period of time for the protection of the beneficiaries. An example of a protective trust, and we've given this its own category because it's specific to certain beneficiaries, are Henson trusts, which are used Canada-wide, and it's typically for the benefit of a beneficiary with a disability. You can have beneficiaries in addition to the beneficiary with a disability, but typically if they have qualified for the disability tax credit, then a Henson trust can be a really good option because the terms of the trust set up so that it shouldn't impact any government benefits that the beneficiary can have. As you probably notice, for disability benefits, typically there's an income threshold they need to be below in order to receive those benefits. And it's not just cash benefits, it can be medication as well. So we want to make sure we're preserving those benefits as much as we can. And the wording in a Henson trust preserves that as best as we can, so that there's still an inheritance for the beneficiaries, there's still income and cash flow to them, but they're still preserving their benefits from the government. Okay. Income splitting trusts are also useful in testamentary documents. And basically what this does is it just allows a larger number of beneficiaries. And typically with trusts, you want to distribute the income that's earned if it's appropriate. And then people claim it on their tax returns and they pay their marginal tax rates. So it's an option to lower the overall potential household tax bill if it's your children that you're naming in there. Instead of just having everything taxed at the highest rate, you can use the marginal tax rates of the beneficiaries. The trustee is typically a family member or someone independent, but they have broad discretion in these income splitting trusts. So they would decide on an annual basis how much is distributed. And this would be primarily income, not capital in these cases, to each beneficiary. It doesn't have to be equal because they are widely discretionary and it can change year to year. And you want to look at other income sources of the beneficiaries in determining that and their needs. But it's broadly discretionary so that the trustee can do what is appropriate for the beneficiaries and appropriate for the estate in dealing with the amounts given to them and how that amounts are reported on each beneficiary's tax return for tax purposes. An inter vivos trust is another way to gift during your lifetime, really. So this is similar to a testamentary trust in that you've got that severing of ownership between legal title and beneficial title. But instead of being set up on your death through your testamentary documents, this is set up during your lifetime. And it would be set up usually through a formal trust deed. And often you may have heard these as described as family trusts, but they're not always family trusts. There's a broad range of inter vivos trusts that can be set up. They can be charitable trusts, they can be commercial trusts, but it's basically that word inter vivos, between the living. It's set up during your lifetime. You transfer assets into the trust, which can be the complicating factor. So we always encourage you to get advice from your advisors. Because it's severing that owner, you are no longer the legal title, so it would not fall into your estate. They should stay outside of probate. And they can be very useful tools for income splitting, for protection, and for probate avoidance if they're appropriate. And that's why we need complex planning, and you need to consider these carefully. Partly it's because of getting assets into the trust. It's not just a matter of gifting assets in, as we'd mentioned before with the inter vivos gifts. If there's inherent capital gains, it is a deemed disposition, so you could be prepaying tax without necessarily having the proceeds from a sale. And we want to make sure that it's appropriate. These trusts, because they have a lot of advantages with income splitting and credit protection, there's some checks that are put in there. So one of those would be every 21 years in Canada, there's a deemed disposition of trust property. So the trust is deemed to have sold the property and reacquired it. And that can be a capital gains event as well. So again, we want to make sure you're speaking with your advisor or someone at ClearEstate who can help you out with that and determine if this is the right strategy for you. So those inter vivos trusts, I'll just touch on very briefly for you. A family trust is often used by business owners where they would have the trust as the shareholder of the company. Prior to 2017, this was a lot more common because you could income split dividends from those private companies. The tax on split income rules that were released in 2017 have limited this a little bit, but family trusts can still be very useful in a portfolio of publicly traded securities, for example. So there's still income splitting opportunities there. If they're set up properly with private companies, you may have the ability to access multiple capital gains exemptions. With the new budget from 2024, this capital gains exemption is $1.25 million. So if you multiply that by several family members, you can get a large amount of tax savings on that. And there's potentially the ability to sprinkle dividends amongst other family members. And as we mentioned with the testamentary trusts, when trust income is distributed out to beneficiaries, it maintains its characteristic, but the beneficiary reports it on their tax return, so you can use their marginal tax rates. If you're dealing with a private company, and again, we want you to be very careful with this and get good advice, because there are some rule changes since 2017, but you can do an estate freeze, which effectively takes the value of the shares currently owned, freezes them at their current value, converts them into fixed value preferred shares, and then a family trust can subscribe for the new common growth shares at a nominal rate. So it doesn't require the next generation, if this is part of your business succession plan, to come up with a lot of money in order to share in the future growth of the business. And it can fund, the original shareholders' retirement as they redeem their fixed value preferred shares over time. If control is an issue, that can be an effective way to do it as well, because the fixed value preferred shares could still have voting rights attached. And so it's a way to kind of slowly transfer a business to the next generation. But as I mentioned before, with the tax on split income rules, we want to be very careful in making sure you're getting very good advice from your current advisors and also from ClearEstate subject matter experts. As I mentioned before, getting assets into the trust can be a problem. If you don't have that business, then you can send assets in through a prescribed rate loan. So this is when you would take cash usually and lend it into the trust. It does need to be at market rates. And so the prescribed rate as of today, it was recently lowered by CRA, is about 5%. And the trust needs to pay that 5% back to you. So if you make the loan, you need to report that 5% income or interest income within 30 days of the end of your taxation year. So you need to make sure your trust portfolio is achieving better than 5% to make it worthwhile. A few years ago, this was a very common strategy because the prescribed rate was around 1%. I think it went up to 2%, and then it very quickly went up to 5% and 6%. If it goes back down, we expect this strategy will become a lot more popular, because the rate that is in place at the time you make the loan is the rate that stays. It doesn't go up as CRA changes the prescribed rate loan. And then if you were curious, it's an average, a weighted average of the Treasury bond rate. So it does change over time. And right now it is a little bit on the higher side. But if interest rates go down, then the prescribed rate loan can go down, and this strategy could become a lot more attractive to you. Trusts can have publicly traded portfolios without being worried about the tax on split income rules or the kiddie tax rules. So it can be a very nice way to split income with lower income family members. But as I mentioned before, we want to look at that prescribed rate, make sure that it does make financial sense for you, because the portfolio needs to beat the prescribed rate interest that you're paying on your tax return. And if you're the higher income family member, it doesn't make sense to just increase income into your hands rather than through the trust. Okay. Oh, and I should also mention the loan could be part of a multiple will strategy as well. So we're going through all these different strategies together. It's not just pick one and that's the best one for you. It can be a combination of any or all of them that might be best for you depending on the assets that you have in your family dynamics. In this particular one, if you make a prescribed rate loan to a family trust, that loan doesn't have to go through probate. So if you were doing a secondary will for other shares, or if the loan was of a sufficient value that it made sense, you can do a secondary will for that and keep it out of probate. And in Ontario and BC, those high probate jurisdictions, you can save the money, the time, and the privacy. Okay. Another inter vivos trust that tends to be even more beneficial is the alter ego or joint partner trust. It's alter ego if it's for one person, it's a joint partner, it's for two. But because these are such lovely tools, they are only available when at least one of the partners is over the age of 65. These are some of the only trusts where you can transfer assets in on a tax deferred basis and not have that deemed disposition and potential capital gain. They're also not subject to that 21-year deemed disposition rule. So even if you expect to live past 86 when you're 65, you can still make use of this strategy and not worry about a taxable event. However, as you might have learned so far with every advantage, there can be small checks. On this one, there's certain assets that cannot go into an alter ego or joint partner trust, and those would be your registered assets. And like a spousal trust, it's only for the named party. So an alter ego trust, it's only for the settlor. For a joint partner trust, it's the settlor and their spouse. They're the only ones who can have the benefit of the income and capital of that trust during their lifetime. Any income that is not distributed to them, if it stays in the trust, and this is the case for all trusts no longer have marginal rates. They're only taxed at the highest tax rate. So we want to be very careful about what income is left in the trust. And not just, they don't always make the most tax sense. So we want to look at whether tax savings outweigh probate savings, if the complexity works for you. There's a lot of different factors that go into alter ego and joint partner trust planning, but really any trust planning. And we want to take a really holistic and customized approach to your estate plan and make sure that the strategies that are recommended to you are the best ones for you. And it may be that an alter ego and joint partner trust is a good one for you because it does get your assets out of probate. It does allow you to move assets in for certain degrees of protection. And you are able to still control the assets as if they were your own. So thank you very much for bearing with me today. If you're interested in any of the topics we discussed, we would encourage you to reach out to your advisor or to ClearEstate, although typically the advisors know how to get in touch with us as well. And so we can continue the conversation and determine if any of these strategies are good for you and start to put that robust estate plan into place for you. Our credo is the best gift you can give your loved one is a planned estate, and we truly believe that. It's peace of mind for you, but it really is efficiency, simplicity, knowing what to do for your loved ones, which can not just preserve family harmony, but can make things better for them at a really tough time. So what is our process? At ClearEstate, we want to look at first, get to know you. In the pre-plan interview, we look at what do you own, because that can determine what currently would happen if anything were to happen to you immediately, and what assets have some opportunities for planning. We look into the actual inventory, which can include the cost basis and the fair market value and how it's owned, which will determine which strategies are available for you. If you have existing documents, we want to review them so we can say, this is what's going to happen. It can learn about possibly who's important to you or who could be decision makers. But we also want to know what is important to you. What do you worry about? Because that can inform the rest of your estate plan. And I know I talked a lot about probate savings and tax savings, and those of course are nice to haves, but we want to look at what is most important to you first and then layer in those savings after the fact if we can. So in your pre-plan interview, we'll look at those personal aspects, your inventory, your existing documents, and then determine what the next steps might be. So after we've done that, what do we need to do? We will look at it. We go through a guidance process and look at which options are available to you and would they work. And we want to keep a certain degree of flexibility depending on your age, because we don't want to lock you into something that you can't change down the road, because circumstances do change as time goes on. We'll recommend which key documents are needed, and it might be as simple as just doing a will and lock you into something that you can't change down the road, because circumstances do change as time goes on. We'll recommend which key documents are needed, and it might be as simple as just doing a will and your incapacity documents, which Ontario are your power of attorney for personal care and your power of attorney for property. Power of attorney for personal care, of course, has a different name, province by province, but it's the same document in allowing someone to make decisions for you for personal or medical reasons. So we'd recommend those key documents. It could be as simple as those three. It could be layering in multiple wills or adding in additional testamentary or inter vivos trusts. It could be changing the ownership of some of your assets right now, depending on what works best for you. So we'll look at those probate avoidance strategies that may be there and if they work for you. And then we have our vault, as I mentioned earlier. So it's our in-house produced platform where you can store all of your information. And it's information on your inventory, but also information on your loved ones that will be needed at your passing, so that if something happens to you, your loved ones can come in and everything is organized and ready for them. And then the third step is kind of an ongoing one, which is how do you keep everything updated? We recommend annual check-ins where you would look at, do I need to update this? Have I added assets? Have I sold assets? Has my family expanded or contracted? What do we want to look at this? And should any tweaks be made to the estate plan, either the documents or adding in other tools that might be ready? We do recommend annual check-ins, but at a minimum, it should be on the occurrence of any major life event. So again, if your family expands or contracts, if you retire, the purchase of a major asset, all of those are reasons to revisit your estate plan, which we're happy to do with you, and see if there's any tweaks that should be made to them. So with our platform, which we call ClearVault, it helps your executor to quickly and easily settle your future estate. So this is moving from the planning into the settlement process. And because you've done all the hard work in advance of identifying your assets with their cost basis and their fair market value, you've identified the beneficiaries and decision makers with their contact information, they should be in much better shape to begin to settle your future estate. So I'll just go through that process quickly as we outlined before. We start with that interview, and then we do an inventory of all of your assets and your beneficiaries. We look at your distribution framework. What do you want to happen? And distribution includes your primary beneficiaries, but also taking it to an alternate. If you have vulnerable beneficiaries or minor beneficiaries, at what ages would be appropriate, what assets would be appropriate. And we put those documents together for you, whether they're multiple documents that are needed or just a few. And then we do secure filing of any documents that are there. So if we offer a professional executor program. If you do have family members who maybe would not be interested in acting as executor, we do offer that service and would store your documents for you. And then, of course, we reach out for annual updates, although you're always welcome to reach out to us as well and determine, is everything still good? Has the law changed? Has your circumstances changed? Do we need to update the documents and tools in any way? So ClearVault, this just kind of shows a brief snapshot. We do encourage you, if you sign up, to really take some time on your ClearVault and see the different tools and dashboards that are in there. But you can see we've got value to the estate, which is your net estate value, your assets minus your liabilities and potentially minus your estate fees, which would be estate administration tax or probate fees, and your taxes to CRA as well. So you can see, what are you leaving, and do you need to bulk that up with other tools, or does it change how you're living right now? And then you can see who at ClearEstate is assigned to you, your subject matter experts, your planners, and your customer service representative who will help you through the process. And we do have a very secure vault, so you don't need to worry about all this personal information that you're providing will be released to other people. Even when you do pass and your family members come forward, we do go through a rigorous identification process to make sure that we're able to release that information and access to them. So I hope you're still with me and that you've learned a lot. I know it can be a bit of a morbid discussion thinking about your legacy, but we do find once you've done a complete and robust advanced estate plan, you will feel better. If you take anything away from today, I hope it's that advanced strategies can be very beneficial, but you must be very careful in your consideration of them and determining how they would work in your family and what is most important to you. How does that play into your overall estate plan? We want to look at all of the pros and cons of each tool that is available to you. Does the cost equal the benefit? Is it greater than the benefit? It might not be worthwhile, but if the benefits are really there, then it could be there. Can it be undone? We'll look at all of those options for you, and then getting the right professional guidance. And we always work with your existing advisors because they know you best, and there's definitely a reason you are with them. But also, if we need to use people outside of your advisor and ourselves, then we'll connect you with the right people as well. And those could be professionals in other jurisdictions. If you're doing multiple wills outside of your home jurisdiction, it could be international tax experts, for example. It could be life insurance advisors if you think there is a hole or a need there potentially. We'll look at who is appropriate to you and how can we connect you to those people to make sure that your complete estate plan is ready for you. Thank you so much for your time today. I really appreciate you being here, and I cannot wait to work with all of you soon. Have a great day.
Okay. Well, thanks for that. And thanks everyone for sticking around and hearing Melinda's talk. Now is a great time for you to be adding your questions into the question box if there's anything that you would like John and Michael and I to address. And if there's something that we need to research, we'll let you know and get back to you. But I can see here that one question has come up, a couple actually. The first one being a very common question, but always worth going over again, which is, what are the pros and cons about adding an adult child to the title of your real estate? So that's something people think about a lot as a great way to avoid paying probate and making sure that something flows from one generation to the next without having to go through that process. That would be the only pro. There are quite a few cons when it comes to adding your adult child to your real estate. For one thing, it may not be accomplishing what you want. If it's a child who owns their own home, for example, that just becomes a secondary property for them too. It opens you up to some potential problems down the road if you've got somebody else on the title of your home. Let's say that they need to go through bankruptcy or they're being hounded by creditors. That can be an asset that's listed under their name that could be vulnerable, and that's your home. So think very carefully about that before you add an adult child to the title of your home. I wonder, John or Mike, do you have something to add to that question or answer?
I guess the other thing I'd add is, in some cases, obviously, if you're adding a child and they have not yet owned a home, you would also potentially be risking them in qualifying as a first-time home buyer as well, too. We've come across that a few times in the last little while where that was the goal, but at the end of the day, they had not yet owned a home, so that would take away their opportunities to maybe pull from an RSP or get other benefits as a first-time home buyer. So, as you say, Ellie, I think it's something that has to be just carefully discussed, because sometimes the goal will not meet what the actual intended benefit would be.
Yeah, very good point. That's right. The first-time home buyer advantages that are out there and hopefully getting better all the time. We kind of have a question that's building on that, which is, should a couple's principal residence be in both names? How does this affect probate? So something you should definitely think about. If both of you live in the home, it's both of your asset. There are different ways that it can be titled. It can be joint tenancy with right of survivorship. So when the first spouse passes, it just easily passes to the surviving spouse. Or it can be tenants in common, where you each own a portion of the interest in the home. And when somebody passes, you don't inherit automatically that portion of the home. It actually becomes part of the estate. There are some situations where that's preferred. It depends on your family dynamics. It depends on your wants and needs, but those are the two ways that it can be done. And so it can affect probate because if it doesn't just flow to the other spouse, it'll end up going through it. Mike, John, anything to add to that?
No, I guess I would just, no, sorry, go ahead, Mike.
No, go ahead.
Yeah, I was going to say, generally, if we're talking about spouses here, obviously, if it's joint, obviously there's that opportunity for it to flow from one spouse to the other without probate. But it generally is not going to have that negative tax consequence because both individuals will have the ability to kind of consider that as being your principal residence. So it won't have the capital gains tax in the rollover, but probate could still be required if only one individual is named on there. So that would be the consideration of what you'd want to do. Generally speaking, most spouses are joint on there unless there's a reason why one or the other is put on there. Sometimes business owners and stuff like that will try and protect themselves. So it's really understanding what the reason was for.
Yeah. So as always, seek the right professional guidance when it comes to questions like this, and make sure they can see your whole situation and understand the reasons why. There's one other question that's just come in as well, or actually it's been waiting since about halfway through the presentation. It's a question about a really small value estate. So if an estate is valued low enough, let's say just 20,000, do you not need to submit the forms for probate? Advantage being privacy in this case. So I believe even when an estate is small, it depends on what the assets are that are still within the estate. You still need to get the authority to act on them. So careful planning, there are ways to avoid it completely, but even a small estate, you may have to file for a small estate affidavit for the estate. And even in Ontario, that's the case. I think it's 150,000 or less. So there's still some filing to be done. They still want to see a copy of the will in the court, even though they're granting you the small estate. I think it's a small estate certificate in Ontario.
I guess the only thing I would add is obviously what isn't in the question is what is that 20,000? If it's a TFSA, maybe a beneficiary could be on there and that would not require probate, or is it an RSP? But if we're assuming it's 20,000 and not in a registered plan where there's no beneficiary, then yeah, it generally would be subject to a probate. But our experience has been that many institutions have some kind of a threshold if they have comfort with the client. Each institution is going to be different, so you'd have to seek out what that would be. Some institutions will not require probate up to 50,000. Some might be 100, but generally once you get to that 100 range, most institutions are going to require that probate. And they said some will even require it at a lower level.
And to add to that specifically, yes, IA, like we have that $100,000 threshold, and that's across, again, non-registered accounts, or even the people get caught. We notice when like an RSP or RIF or TFSA, if you're not naming a beneficiary and you're naming the estate as the beneficiary, that will lead to probate. So we have seen that where, people think, let's just name the estate, everything is going to get passed through the will, but then that does lead to probate. So again, that's depending on your situation, but that's why we do prefer having that named beneficiary on those registered plans.
Right. So again, we're going to tailor it to your particular needs and your particular situation. There you go. One thing I would like to point out as well, while we wait for another question to come in, if it's coming, we could give you a little time back, but a lot of what Melinda was going over was about trusts. And I just want to point out that they're great tools, of course, and there's going to be times when they are the right thing to do, whether it's inter vivos or it's a testamentary trust of some kind. But you do want to consider that trustee relationship. We have a lot of situations where, someone set up a spousal trust and it's the second marriage, and the trustee of that trust is the son who stands to inherit it eventually down the line, right? That's a conflict of interest. So think about who you're going to be putting in place as the trustee. Another situation for a Henson Trust, for example, lots of our clients have come to us to set those up, and they're thinking, well, I'll just name my other child as the trustee for that trust. Again, especially in the case of a Henson Trust, that could be a decades-long relationship, right? That could go on for a really long time. Hopefully it does. But putting that burden on your other child can be a lot more than they bargained for. So in these situations, you might want to think about putting a professional in place. And when you name ClearEstate in your will as to settle the estate, we can also act as trustee. And then these trusts can also be managed by your trusted investment advisors here, John and Michael. So just something to consider. Trusts are an excellent tool, but they can be a lot of work for the person who's named as trustee, who's going to be carrying out your wishes and making sure things go correctly.
Any other questions?
And I'm not seeing any more come in, and that's okay.
Well,
I think we had a informative evening.
good. I think we'll wrap things up. Ellie, I want to thank you for helping us put this evening's event together, but more so I want to help you in working with us in all the other 4 as well too. Really appreciate all your efforts in that of ClearEstate, so thank you very much. Want to also thank Melinda for obviously providing a very thoughtful and insightful session on some of the areas of advanced estate planning. She did a great job in sharing with us obviously the elements of probate, but some of the other more difficult and strategic strategies on the estate plan. As we kind of complete this 5 series kind of event on estate planning, it's been very highly successful. The goal for Michael and myself was to really bring that awareness to our clients. Through our meetings with clients, we recognized that there was a gap in some of the estate planning items that we've seen our clients were doing. In some cases, they hadn't done it yet, which was of a high concern to Michael and myself. And in some cases where they did have it, it was sometimes an estate plan that was 20 to 25 years old and many things had changed. So, the good news is that over the course of the last year in bringing this together, we've had a chance to sit down with a lot of our clients to either get the estate plan in place or at least start the process. And in many cases, get those updates to what some of the older plans would be. So from our perspective, it's been great to partner with ClearEstate to bring this awareness. So again, thank you to them. As Michael had mentioned in the opening, this event or this evening's event was recorded, so you'll have access to it on our YouTube channel. Just give us a week or so just to get all the technical side up in place, and then we'll post it to our YouTube channel. And in that YouTube channel, the other 4 sessions that we did, some of the ones that were dealing with some of the more basic and common themes that a lot of you will deal with are already there. So you'll obviously be able to get some value in that. And on that, I really just want to thank our clients for investing their time this evening and getting a little bit more information and informed on estate planning. And on that, we'll say good night.
Good night.
Okay. Thanks, everyone. Good night.
Good night.